Jacinta Ardern.
Thank you, Mr. Speaker. And it's right, I think, before I begin, Mr. Speaker, that I acknowledge the contribution that Select Committee members as a whole have made to this process. As Mr. O'Rourke pointed out, there were a number of issues that were raised in the first reading of this bill, which were, by and large, subsequently addressed by the committee collectively. But I do think Mr. Mitchell raised some questions over Mr. Goff's speech, but I think it's only right that Mr. Goff does take some credit for some of the changes that were made, because he did pursue them feverishly at the Select Committee, and the Select Committee agreed with him on a range of the issues that he raised. Mr. Speaker, probably one of the reasons that Mr. Goff was so vehement about, I guess, increasing the range of people who would have access to this bill is because he himself, as Minister of Justice under a Labor government, championed victims' rights through things like ensuring better support for victim support and their ability to do their job. They've now become a core component of our justice system. They're not just a voluntary organisation, but are now a part of ingrained referral process from our local police, but also trying to create a charter of victims' rights, as it were, what a victim can expect and should expect from our justice system. So that was really groundbreaking, Mr. Speaker. And these kinds of amendments to our law just take that a step further and acknowledge that there continue to be gaps in our system from the perspective of the victim. To put this particular bill, the Victims' Orders Against Violent Offenders Bill, into context, there are 1,150 offenders of serious or violent offences at any given time. But in a 2-year period, if we take a snapshot between 2008 and 2010, there were roughly in that period 280 protection orders issued and 78 restraining orders. Now, the reason I raise that is because the victims' orders are intended to be another tool to be used by victims where they feel the same threat that might apply to someone who uses a protection order or a restraining order, but in different circumstances. And what I think those numbers demonstrate is that they're not used perhaps as frequently as they otherwise might be. Now, that sends us a range of messages that I think we need to pick up on, one of which is that there was a gap for some victims that wasn't covered by protection orders or restraining orders. Now, as has already been mentioned, the bill, the actual gist of the bill is that it allows the courts to issue a non-contact order, which is in essence in the nature of a protection order under the Domestic Violence Act, so has a similar effect. For a victim of a violent crime. Now, that order can last for 2 years unless the court specifies a different duration. So the 2 years is if the duration is not specified, if it's left open-ended, it essentially will lapse after that 2-year period. But as I've said, the court can specify a longer period if it so wishes. Now, when the bill came to Select Committee, violent offences, because that's essentially what this hangs on, was the criteria for that was a violent offence that had a sentence of 5 years or more. Now, that's not to say that that was an offence that had a range attached to 5 years or more. It was whether or not the prisoner received that sentence. Now, our concern was that that could lead to an anomaly, that you could have, for instance, 2 victims who experienced the exact same serious or violent crime, but their offenders had 2 different sentences attached to them, one which could put them within the threshold of having a victim's order, the other which would not. And we thought that seemed manifestly unjust. Now, the easiest way to deal with that was to simply lower the threshold. And our view was that there was very little harm in capturing a wider range of victims, because by the definition alone, they had a serious violent offence committed against them, and that actually the sentence attached to that shouldn't really be the prohibitive factor in whether or not they're able to access a victim's order. So we had a good discussion about that, and I think we came out on the right side by agreeing to reduce that threshold, because it was an arbitrary decision ultimately that had to be made to a 2-year process. Mr O'Rourke has already raised probably what was the most significant second change that was made by the Select Committee, and that was the point in the process in which a victim was able to access an order. Now, when the bill came to us, essentially a victim had to wait until an offender was released before they were able to seek through the courts for an order to be made. Now, that just didn't seem to make any sense to us. It allows a gap, as it were. Now, if the whole purpose of this bill was to give an offender, a victim, a longer stretch of time in which they can feel, whilst that offender is reintegrating back into the community, that they have that extra set of protections around them, that if that was the intention of the bill, why would you allow a gap upon immediate release where that protection didn't exist? And it didn't seem to us to be that was the intention of the minister, that perhaps this was just a structural issue. So that's why we made the sensible and necessary change that essentially now these orders can be handed down any time after sentencing. So there is no gap between release and there is a wider scope to the orders than parole conditions could provide. Now, that for us was also an access to justice issue. It makes it easier if a victim is able to deal up front all at once with all of the trauma that comes around court processes, and trying to consolidate that into one process was one of our aims. That doesn't mean that it's still not a prohibitive process, and we were concerned that there is a cost attached for an application for this order, because it is a civil proceeding, and that yes, you could use legal aid, but legal aid thresholds, unfortunately under this government, are such that very few people are eligible now. So we maintain that concern, and it's one that we wish as a party to put on the record. One extra additional element, Mr Speaker, that I think is important to raise, because it wasn't really the primary focus of the original bill, was the wider scope that we wish these orders to have. So when the bill came to us as a Select Committee, it was heavily focused on putting restrictions around an offender, and an offender alone. Submissions, though, demonstrated to us, Mr Speaker, that actually an offender, when they're in prison, is even able to breach an order. And they can do that by communicating, in the examples we had raised with us, by communicating with gang affiliates or family or friends, and requesting that they engage in harassment of a victim, or undertake certain tasks which could be deemed to be harassment because it was at the hand of the offender. Now, we heard first-hand examples of where that had happened, and it was our view that it would be sensible to allow for a protection order to extend not just to the offender but to their associates if it was under their instruction that they were acting, and particularly alarming for us to have heard that that was happening whilst offenders were in prison. So we felt justified in making that extension to associates of the offender in certain circumstances, and that those penalties could apply to those associates who are acting knowingly against that order. All in all, Mr Speaker, we support this bill. We think it enhances victims' rights. We're glad that we had the ability to, I think, improve the bill as a Select Committee, and I look forward to further debate at the committee stages.
Joanne Hayes.
Kia ora, Mr Speaker. I'm pleased to take a short call on this bill. You know, we New Zealand